Another trap for the unwary in the intellectual property area is the marking requirement. Contractors are required under the regulations to specifically mark the ownership rights that exist to all of the IP. If not, the government can acquire unlimited rights to the data. Computer software also needs to have these markings. There's a records keeping requirement that must be met as to these markings as well. The contractor has to maintain records which show and justify the validity of any markings and be prepared to provide that to the contracting officer and a justification if requested. It becomes a diligence item for purchasers, and Target should be prepared to provide the evidence that all the markings are appropriate and valid under FAR and DFAR. And I should have backed up and said, for those who don't know, FAR is the Federal Acquisition Regulations. DFAR is actually Defense Federal Acquisition Regulations, which apply to certain particular defense products and services. This is an issue that purchasers need to be particularly careful about, particularly if they are a purchaser that is a large government contractor or a government contractor buying a target that is also a government contractor, with the idea that there's a certain, and if part of the business objective of the transaction is synergies between the two entities, and there's going to be sharing and in effect commingling of the IP, you're going to want to be very careful and very certain that the markings have been done on the target before you acquire it have been appropriate, so that when and if the IP is commingled, and I do think many contractors actually don't commingle IP for this reason, as well as maybe some others, but if they are commingled, you don't want the targets, you don't want problems with the target's IP ownership rights to taint what may have been very clear title as to the purchasers before the acquisition took place.